Hello everybody, welcome to another episode of Lunching with Lawyers. Today I've found my way all the way to Melbourne and to the lovely Emma Swart, who is a Melbourne barrister who practices predominantly in family law. She is also an accredited mediator. She's represented the Victorian Bar on the Law Council of Australia's Domestic and Family Violence Taskforce and the Law Institute and Victorian Bar Legal Aid Taskforce. She has authored numerous papers and submissions both in family and credit and debt law and helped coin the phrase sexually transmitted debt. She is also the woman who was my first principal in practice when I started my legal career in Western Australia. Welcome, Emma.
Thank you, Loretta.
I was hoping to conduct this interview in your new chambers, but renovations are ongoing, so we are in the Richard Griffith Library at the Owen Dixon Chambers, where I hope we won't be disturbed. Actually, before we start, let me ask you this question. What are chambers and why do barristers use them?
Chambers is a term which is used to refer to a legal office, and that's really come back down to referring to barristers' offices and judges' offices. So they call them chambers in the court as well. And we refer to chambers, and it's a collective as well as an individual. So I have a room in Chambers which is called my chamber, but Chambers is also the name of the building.
Oh, how exciting is that? It's just some fancy pants word for office.
Yeah, that's all it means. It means there's an office. So I have an office upstairs, which apparently is finally going to be ready next week from having been renovated for me.
Excellent. So Emma, you were born in Walgett from Dutch parents. How was it that they found themselves in such a sleepy little town in the mid-1960s?
Well, my mother's actually a Sydney girl, so she's Australian-born Sydney girl, and my parents met when they were both studying after the Second World War at Sydney University in science, and then they went on to do Teachers College. Dad was a Dutch returned serviceman who'd come to Australia and taken advantage of the assistance in getting into university, which he missed out because he was 18 when he was drawn into the armed forces for the Second World War. And along the way, much to everyone's surprise, my father felt a call to become a minister of religion. And he went back to theological college, and the first student placement that he was sent on was to Walgett, up in the black soil plains of Western New South Wales, beyond Dubbo, and my parents spent a year there. I took a road trip finally just before my 40th birthday to go and have a look at the place where I was born, and I stood outside the house that Mum brought me home to from the Walgett District Hospital, and I rang her and I said, "Mum, when you got here, did you cry yourself to sleep?" And she said, "Oh no, I was far too tired to cry myself to sleep and far too concerned about where the mosquito net was for the baby." But it was a real adventure for them in outback New South Wales, and they often talked about the people that they met. And I think the permanent congregation in town was about 8, and Mum dusted off her piano playing skills and played the organ. But they did regional visits, and they'd go out to homesteads where surrounding landowners would fly in for the once a month service.
And did they find that there was a great level of acceptance being Dutch? Like your father would have had a Dutch accent at the time.
Apparently quite a strong Dutch accent, but he never even mentioned it being an issue. So I think there was a high level of acceptance, and they also told stories about the opal miners at Lightning Ridge, which was just up the road, and my older sister was given the pick of a little tray of opals and picked the smallest and the nicest and the most expensive. Unfortunately, her little sisters played with that and it got lost somewhere in our childhood.
That's a shame.
Yeah.
Well, when did you then first know that you wanted to study law, Emma?
During year 12, I had a very strong career path in mind, or a university path in mind, and I wanted to go to Melbourne University, and I wanted to study psychology, and I wanted to study Dutch. So Melbourne University was the only place where there was a Dutch course available in Victoria, which is where we were by the time I finished school. And it was only, I think, while we were studying for the exams for, the break between school and year 12 exams, I thought, maybe law would be a good thing to do. Passing thought.
Chuck that in.
passing thought, but I didn't get the marks to get into law at Melbourne and thought nothing more of it until halfway through first year arts. And I can remember it quite clearly thinking, I can't believe this. This is a fabulous life, this study thing, and it's going to be over in only 2.5 years. Hang on, I thought maybe I'd do law, and I went to see the subdean of law, and I said, is there any chance I can transfer next year? And he looked at my record and said, yep, if you get me at least credits, you can come. And then we had a regular meeting with friends that I'd made at a hotel. I don't think I was actually 18 yet, people, but it was a regular lunchtime at Norton's Hotel because we didn't have mobile phones. We couldn't catch up with each other unless we made arrangements and had spots to meet. And
there just wasn't the checking of people's...
No. You didn't need photo ID. And so exactly that same week, there were 3 of us there waiting for the others, and, well, I have news, says one. Well, so do I. So do I, says the other. And one of my friends, halfway through first year science, had been to see the subdean of law and had been told he could transfer. And another one of my friends, halfway through first year arts, had also been told the same thing. So it was partly a love of that student life, but also a little bit of a concern that what was I going to do with an arts degree? That there wasn't a defined career path, and a memory of my teachers in secondary school saying, have you thought about law?
And I wonder, did you then were your 2 majors then in your arts degree Dutch and psychology, or what were they going to be?
Oh, well, every year we'd go to enrol at university, and Mum would say, having helped us work out what we're going to enrol in, and she'd say, so what did you end up enrolling in? So I ended up with not a great love of psychology at that time, because it was very science-based and statistics-based that just didn't speak to me. And I took an interesting general first-year subject, which allowed me to then major in politics. And I had a couple of years of the Dutch department, which was a wonderful small school with lots of social interaction, and things that I learnt there led to little travel ambitions in my life. So I did a subject from the Germanic Studies department, which was called Old Norse Myth and Hero, which my mother thought was Old North Missing Hero all year and was a little confused about it. But the lecturer had a voice like honeymead, and he had a great love of Iceland. And he told us so many stories about Iceland and Iceland's role in preserving these beautiful old stories from Norse mythology, that when I eventually headed off to Europe by myself, on the agenda of my 4 months trip was a month in Iceland, and it was wonderful.
A month? You spent a month in Iceland?
I spent a month in Iceland.
Wow. Because the weather is not that predictable.
No, it is very predictable in Iceland. The top temperature in the middle of summer at that point before global warming was 16 degrees Celsius.
Having spent a few days there, it was just one day was okay, the next day was just so cold. I couldn't believe it.
The thing that I didn't realise about Iceland is that rain is not just vertical, and not just diagonal. It can also be horizontal, and then it can come from the ground up. So,
But did you end up going to the Blue Lagoon?
yes.
Oh, that's an amazing experience, isn't it?
Look, it was beautiful. I really loved the hot tubs, and one of the things about Iceland that inspired me was the thermal heating, and the fact that having a hot tub in your backyard was a normal thing for an Icelander to do, and they had the ready supply of hot water because that's how they heated their houses, taking the thermal hot water.
And the streets, don't they?
Good, and because of the only reliance on fossil fuels was for motor cars, the air was so clear. You could see mountains that were a long way away, and that was an experience that I hadn't had growing up in Australia with that blue eucalyptus haze of the distant mountains and them being far away in the distance. So
I don't think much has changed there. I was in Reykjavik a few years ago, and I thought it was like a small town because now I think about it, it's because the air was so clear.
Yeah, the air was beautiful and clear. And the other thing for an Australian, and I had a great interest in photography and still do. And I can remember I did a 2-week camping trip, and the communal tent was a teepee. And I was standing in the doorway of the teepee because there was a beautiful conical mountain, and the sun, in my Australian sense, was going to go down straight behind it, and I expected it to be backlit with cloud. And I kept putting my head out of the tent, waiting for the sun to be at the right angle. And I was speechless because the sun went down diagonally. And at that moment, I felt like I was an incredibly long way from home, and it was absolutely wonderful.
It is. Oh, look, I mean, what an adventure, Emma, really. But let's get back to the law.
Okay. We always come back to law.
I'm assuming you took your PLT course at Leo Cousins.
I did.
And I noticed that you taught at the Leo Cousins Institute for over 20 years. How did that start? And really, why the interest for Leo Cousins in consumer law? Because it's not a great area for lawyers to go into after they start practicing, particularly if they're trying to represent the interests of consumers.
So I didn't apply for articles at all because I ended up, after a long slog at university, my, enthusiasm for not being finished after 2.5 years wore off a little bit after a year with glandular fever and problems with things. So it was a little bit of a slog towards the end. But I really had no sense of what area of law I wanted to go into. And I thought there wasn't much point in going into an articles program that then locked me into something when I didn't have a sense of what things were like in practice. So I applied for and went to the Leo Institute. And one of the things that was fantastic about that is that we had a cohort who I still am in touch with, some of the people from that course all those years later. And it exposed you to a range of practice areas, and you got a sense of what worked. And I can remember in particular a lecture that Dennis Nelthorpe did. And Dennis came down and he talked about the things that the Consumer Credit Legal Service were working on at the time. And he talked about the truck finance issues. And he told the story of the young guy who was troubled by being unemployed, who went into one of these truck finance offices where they said that they could organise a life plan and a business for people. And they signed him up on a refrigerated truck for him to buy into that, and they'd be carrying fruit down from Queensland down into the southern states. And he was so enthusiastic about this, and his parents were so excited that he wanted to do something that they put their house up as a guarantee for him to do it. And there were a couple of practical problems. One was he was too young for a semi-trailer licence at the time, so he couldn't drive the truck himself. And the other was that you made the money on the load going south, but it was a little hard to get a backload for a refrigerated truck going back into Queensland, and the whole thing was a complete disaster. And for me, that story just resonated on a lot of levels. And when I did, in a time of great employment, and I was very grateful that I'd finished at that time because I did pay my Supreme Court admission fees on my credit card, I walked straight into a job, and I was doing insurance litigation in the city. And that was fascinating. I learnt a lot. I was going to court every week. But because I was junior, what I wasn't doing is seeing any real people. And I thought, what was that story? And I went and volunteered at the Consumer Credit Legal Service in my first year of practice. And not long after that, they got funding for a junior caseworker. And that's how I ended up going into consumer credit law.
And I was going to ask you the question how you got in there. So it was that serendipitous meeting in some ways at the Leo Cousin Institute that meant that you got to work at the Consumer Credit Legal Service. So I was going to ask you in relation to that, what was it like to be one of those first casework solicitors at an organisation like that was run by two very different personalities with Dennis Nelthorpe and Paul Bingham?
It was fascinating. I was 24 years old. This was my second legal job, and they were passionate advocates for consumers, and they were, both of them, brilliant in their own ways and in different ways. And I had to find my space, and I had to work out, I had to read the Credit Act. I sort of resisted doing it for a little while because it was a little overwhelming. But after a few weeks, I thought, you know what, I have to stop asking Paul, what section is it that says this? And I can remember just spending a weekend just reading the Credit Act from start to finish. And then I went and read the little book that Paul had written about the Credit Act, the Credit Handbook, from start to finish. And then I felt that I really started to get on my own 2 feet. But it's partly a different personality. I needed a frame of reference in order to understand it. And that for me then, I think when you're 24 and you're starting practice, your brain's sort of legally empty.
It is.
So sections of the Credit Act I'm more familiar with still than sections of the Family Law Act, in which I've practiced for 20 years. Because it was just, everything was new. And
it was new for the profession as well, because you were in a really exciting time. This was the new area of law that was going ahead. We had the Trade Practices Act, as it was called then, in 1974, and this was like a big deal for credit providers.
Yeah, well, the legal service was working under the then new Credit Act.
Yeah.
And it come into play only about a year before I started volunteering there. And everything was a test case.
Yeah.
We were actually surprised sometimes when we found that words and phrases had been defined in other legislation that were relevant. And what we could do was limited only by our capacity to sleep and, downtime. So it was on one level, high pressure, on the other level it was really exciting. And for me, I'll tell you a little story about being 24, working with two very different, strong 40-year-old men. I had to learn how to negotiate things. And this is something that I've passed on now to junior lawyers over the years. And I can remember saying to Dennis, so how do you do this? And he said, oh, well, watch. And he got there and he picked up the phone and he had a negotiation on what to do with a car contract or this. Mm-hmm. And I thought, yeah, I don't think I can do that. And then I sort of thought, well, I better ask Paul. And he said, no, negotiate. No, I'm about to ring someone. I'll show you what I do. And he said, right, I've looked at this and this is what needs to happen and that's what we're going to do. And he hung up. And I thought, yeah, no, I don't think I can do that either. And I sort of looked at the thing and I thought, no, you actually need to build your negotiating style on who you are. And I wasn't going to be able to be, highly technical, abrupt. I wasn't going to be able to be political, wheeling and dealing, because that wasn't who I was. Dennis could settle any case on a street corner and Paul could win any case in court. But
what a great combination, though.
Oh, phenomenal. And I looked at it, and after a little while I realised that I could settle any case with a particular credit provider if I rang after 5 o'clock. And it wasn't something I was doing deliberately at the time, but we'd get to 5 o'clock and the phones would stop ringing, the secretaries would be finishing up and going home, and I knew I could catch him in the office, and so I was just catching up. And because the pressure was off after 5 o'clock, I'd ask about how the new baby was going. And with his mind turned to home and hearth, he was so sympathetic to any story I could come up with that after 2 years after I worked this out, he started going home on time.
I was too worried about you. Was that around the time when you coined the phrase sexually transmitted debt with Jenny Launton?
The sexually transmitted debt story sort of started I'm not exactly sure of the timing, but what happened was this. So for at least the first year of running cases at the Consumer Credit Legal Service, I didn't lose one. And I hadn't actually lost a lot of cases that I was instructing in personal injuries for the insurance firm either. So when we lost a particular case, I was completely devastated because I had no professional skills in losing.
And isn't that funny, because somebody mentioned to me a few months ago, this is one thing that they don't teach young lawyers as well and law students, that statistically you're going to lose 50% of your cases, and people are very surprised the first time it happens.
Well, yes, I can remember when I was at the bar, the clerk saying to me, Emma, we send 2 barristers out and, one of them's going to win and one of them's going to lose. You were going to have to lose sometime. But, at the bar, we've got it sorted. Barristers win cases, clients lose them. But so anyway, back to the sexually transmitted debt story. So we'd lost this case and I knew that there were problems in that particular case. There were 5 of them. And the tribunal member liked to read his judgments out in person. So there was a great deal of drama over them, being handed down. And I listened as we won each of the 5 points that I was worried about in that particular case. And then at the end of the case, he said, but I find that Ms. X accepted liability as a joint borrower on this case. And I'm thinking, well, how can you do that? If she wasn't the principal borrower, the law that we were applying at the time said you're a guarantor and you need to be treated as a guarantor, and if you don't do the documents for a guarantee, you've got an unjust contract and you can get the person taken off the credit contract. How can you, just because they'd been in a sexual relationship together, assume that she didn't have a separate legal interest from her former partner? But my reaction was to come back and storm up and down in the office, and I can remember myself pacing up and down going, well, that's it, I might as well give up on this job now. And I can remember Dennis laughing at me. And he said, you ready to calm down and have a chat about it? And he said, you didn't see that coming, but I think you might be onto something. And what you need to do is you need to actually get some people together and start a conversation to find out what is going on, not just in the law, but in public perception. And, you know, my reaction as a litigator had been, well, I'm going to get another case and I'm going to go back there and I'm going to win the other case. And his reaction as a politically astute lawyer was, no, if you're in the same climate, the same thing's going to happen to you again. And he said, you need to find out what's going on. So we started the Women in Credit Taskforce. And we sort of talked for about a year. I also had in my head at this time a comment that I'd made when I'd been invited to go and talk about women in credit. And I can remember talking to them saying, I don't know, it's really a gendered issue. You know, credit's a problem for everybody. It doesn't matter whether you're male or female. And once I said that out loud, I started to check that. And we did a lot of telephone advice calls at the legal service, which meant we had this ready source of consumer experience. And I'm thinking, I think that's a gendered issue. I think that's a gendered issue. I've really missed this because I was so, you know, overwhelmed with the enormity of the whole credit problem in itself. And we ended up with a little bit of funding for some pamphlets on women in credit. And one of the people on our task force was one of the legal officers for the Consumer Affairs Department. And she ran it by their publications and they said, we've been looking for a publication like this. Can you ask them whether we can do this? And they were going to, we had $2,000. They were going to spend $10,000, $15,000, $20,000 and put the whole campaign out there. So at the end of our year's work, we handed it over to the government department and got this wonderful coverage, but we still had our $2,000 grant. And we thought, well, what do we need to do with that? When people come for advice on these issues, we're going to have some advice for workers. So we turned around and Anna Taylor, who was a wonderful financial counsellor at the time, was available to pull the whole little publication together, and we did the first little book, which got called How to Get Out of Sexually Transmitted Debt. Now, why did it get called How to Get Out of Sexually Transmitted Debt? It was because we've been a bit cheeky throwing around the meeting, and we thought, we've got to get the attention of the caseworkers. And they, you know, people get overwhelmed, and we wanted to get it out there in the different neighbourhood centres. And we thought, well, that'll get their attention. But of course, who loved it? The journalists.
Of course.
Of course. So it was all over, you know, we'd get magazine articles, we'd get all sorts of different things with sexually transmitted debt. Then we were delighted to get a request from Belinda Fellberg as to whether or not she minded if we used her title in a doctoral thesis. And she ended up writing the book called Sexually Transmitted Debt, based on her research of English and Australian cases. So,
isn't that a wonderful story?
It was fantastic.
And how it just always comes about, like, just by chance. You're in the right place at the right time. You talk to somebody who says, let's take a political angle rather than a casework angle, and off you went. And then having the funding fall into your lap, all those sorts of things.
But it was also, giving it a name was interesting, because instead of people saying, I don't know what to do about this situation I find myself in, they would ring up and say, I've got a sexually transmitted debt problem, and the subtext is, and I know you want to solve it for me. And I was thinking, wow. And so after that first stage, before the next stage is when I did my trip to Iceland. All right. So I had 4 months off, and I came back, and I was then introduced to the staff of the new Banking Ombudsman's office, and sitting around their first office boardroom in Carlton. And I thought, so what sort of cases are you getting? And they sort of started talking amongst themselves, and they're saying, oh, well, we've got this and we've got that, and we've got these STD cases. And my mouth must have just dropped open. And they sort of said, oh, no, sexually transmitted debt. And I said, I know what it means. I just can't believe you're talking about it. Oh, yeah, we've got a whole lot of people that are, contacting us and we've got this and we're doing this with it. And it was wonderful to see, just wonderful to see.
But you then moved to Western Australia, where you went to the Consumer Credit Legal Service Western Australia, where I met you. But that service had only been running for 6 months, something like that, was it? What was some of that? Because you went there going from a casework solicitor, senior casework solicitor, to running, initially as principal lawyer. So
the only lawyer.
running the legal practice. What were some of the challenges in doing that? And how did you promote the growth of that organisation? Because by the time you left, it had a number of lawyers working there.
Yeah, it was really interesting. I'd been over to Western Australia on holidays, and I was thinking about what I wanted to do next, and I was thinking about returning to study and doing some work part-time. And they said to me, why don't you come over here? And I was, I don't know whether I want to do that or not. And I can remember having the question put to me, right, come on, are you going to come? And I thought, well, when do you need to know? And they said, it was 6 days. and I'm not someone who rushes into decisions, but in life you have to make decisions, right? And so what I did in this time was I thought, right, I'm going to divide that in half. And for the first 3 days, I'm going to think as though I'm going to Western Australia. And I was sort of feeling quite comfortable with that. And after 3 days, I rang them up and said, I'm taking the job, because as soon as we got to the halfway point, the sense of loss of the opportunity of what that might be of that experience of going west was so overwhelming that I knew I had to do it. And it was a fledgling service. It had started with only half its funding, and it got that funding late in the year, so it didn't actually have funding secured, and that became the first problem. And talk about opportunity for things. So we were in a queue that had been sort of etched in stone for federal legal aid funding for a long time, and trying to get some survival money. And it was the time of the Olympics. And, and I was sort of looking at things, and the Legal Service Committee had said to me, we'd like you to do a press release every week because we want some publicity. And I was thinking, yeah, that's not going to work. And I said, if you'd like me to get publicity, please give me that job. But it won't be every week, because you get publicity if you've got something to talk about. And the bankruptcy figures came out, and there was a big fuss in New South Wales because they were double. And I thought, my perception is that bankruptcy is much more of an issue here in the West than it is in the East Coast, because the debt recovery laws in Western Australia at that time were archaic. They were. You could take for a man's debt, everything his family owned, except $100 clothes per adult, $50 per child, tools of trade, and the family portraits or photographs. That was it. So, of course, people went bankrupt because the federal protection was much higher than the state protection on debt recovery. And so I got the ABS figures out as to how many people lived in WA, and I drafted a press release and, put in for typing, and then I corrected it. And by the time it got out there, it was ready to go. It was a couple of days later, and I thought, we might as well send it because they want me to send press releases. So in the fax machine, off on the little broadcast fax to all the little media outlets. And I got a phone call from the television crew that were doing the station that had the Olympics. And they said, this sounds really interesting. I said, yeah, it is. They said, do you think it'll keep till tomorrow? And I'm thinking, well, it's kept since Tuesday. Might as well do it. So they said, we're a bit busy today, but we can get a film crew. Do you mind doing it? So they came to my house and we went across the road to the park, and I did a little interview for them, and it showed on the Saturday night of the Olympics, where everyone was watching that news channel, including the people who were making the funding decision the next week at legal aid as to who got it. And it was, I saw that new lawyer from the legal service on TV. It'd be a pity if they closed before they even got going. And we got the federal funding.
Wow.
Just, random chance on things. So, having worked on that, we were then able to really sort of become a player in the national negotiation about what happened with all the mistakes that had been made under the Credit Act. And it was phenomenal. You probably remember from when you started. And I'd say, what sort of contract have you got? Have a look for this, this and this. Because you could actually tell by the mistake which credit provider it was, and it's whether the form was ambiguous. One of the big banks had a form that said that the amount borrowed had to be in the round hundreds. So what the bank staff did was they rounded it up to 100, which meant that they were charging people for money that they'd never given them, which meant they were in breach of the Credit Act, which meant that people didn't have to pay the interest on the contract.
Because it was strict liability. You didn't have to pay the interest.
That's
if they
right.
made any mistakes.
So a lot of our work ended up being these big group actions where the credit providers realised that they had a mistake that had been multiplied thousands of times across their whole portfolio of consumer contracts. And what they did then was they had a capacity to apply for relief from the credit tribunal. And we sort of had these reverse class actions, as it were, where the credit provider was taking action against a whole lot of consumers, and we would advertise that we could take on some people so that we had examples. And then we'd be able to represent a group of our clients and the interests of that general group in these tribunal actions.
It was pretty exciting times because being in the legal centre at that time, we were really mixing with the top legal firms. And
I know.
Here we were.
I remember when you started. And I don't know that you'll ever understand the difference that it made to me to have you there. You wouldn't have had any idea, but I was there and I was working by myself as the only lawyer, and there weren't very many lawyers in legal centres in WA at the time. So lawyers were in a sense precious and rare commodities. The wonderful Jill Toohey and Helen Lawrence had been the backbone of legal centre movements. And when we were, you came along and you needed to get some practical experience and choose what pathway you were going to take in law. And you said, now what would you give me to do? Would I be doing research, or, would I be working on cases? I'm thinking, research? I need someone to work on cases. Yeah, you'll be working on cases. I can guarantee you that.
How long did it take before I needed to take phone calls? I don't think it was very long. And I used to either come to you or Alexis and get the answers before.
Well, it's like, put them on hold. Now, come and tell me what it's about. And I do remember when later on when Michael Hovain started, and he said to us, and he was used to knowing what he was doing, and he'd been working at Legal Aid and doing advice on a variety of things, and then he started in the job, and I was walking past and I thought, there's something on that contract I haven't told him. I said, put it on hold. And I said, no, you've got to look for this, this, this and this and such and such. And he said, we should be writing all this down. That's a good idea, Michael. Why don't you do that? And a couple of weeks later he said, yeah, no, it's too big.
It was.
I'm just going to fill up my water. Sorry, people.
No. Well, I think if we need to, we can actually edit it out. But I think it'll be fine. But they were heady days. But in 1995, you decided to move back to Melbourne after your father passed away. Was it a struggle finding your feet back when you came back to Melbourne?
It was very interesting. Because I'd been looking for jobs from Perth, because I decided, that experience of having Dad die when I was on the other side of the country, and there being one seat on one flight, full economy back to get to Melbourne that day. And it made me actually have to think about, was I going to become West Australian, or was I going to, I had to choose where I was going to live. And I thought, well, the legal service was in a good state to leave. It was ready to hand on to someone else. I think we had 3 years funding in place, and we had 4 lawyers employed, I think, by that stage. And I thought, well, no, it's perfect. And I also rang Jill Toohey, and I said, Jill, how come, I've worked so hard to get this the way it is. How come I don't want to do it anymore? And she said to me, not everybody's the same in the world. There are some people that start things, and there's some people that run things. Maybe you're someone that starts things. And I thought, so I've never forgotten that either. Never forgotten that little piece of advice. So coming back without a job, and I was looking at work in Sydney, and one of my friends that had worked in Sydney said to me, from where you are, they look really close, those 2 cities. They're on the same time zone, but it's still 1,000 kilometres between the two. If you want to go back to Melbourne, Melbourne is where you should go. And you should give yourself, the chance to do that. And I thought, well, I never actually did the return to study that I was going to do after I finished at Victorian Legal Service. Maybe I'll do that now. So I started, just some people that start things, not finish them. I never finished my masters, but I really enjoyed sitting down and thinking about issues. So I studied electronic banking law at a master's level. I did superannuation law at a master's level, and I was really engaged in doing that deep thinking about those issues. But one question that came from those consumer credit days was an absolute bemusement among the whole sector of financial counsellors and credit lawyers about what family lawyers did about debt. And I thought, I'll do that subject on family property so that I'll get an understanding about.
Because I don't think we had a very good understanding of it either. So.
No, but what we had coming back time and time again were people who had indemnities against debt in their family court orders, and then the other party's gone bankrupt and they end up having to pay the debt anyway. And so from a financial counselling and credit law perspective, it's why didn't you just fix up the contract, and why not fix it up back then? So I was a bit curious. So I studied family property law with the wonderful Dorothy Kovacs at Monash University, and I found that so interesting that I ended up doing another subject on creditors and family law. And by this stage, I reminded myself that way back at age 24, when I finished my degree, the idea that I had was that I would like to become a barrister, but I got a little bit distracted along the way with all the things that I'd been doing. So I looked into coming to the bar. And when the clerk very delicately, because there was a little bit of sensitivity about asking women coming to the bar whether they wanted to do family law, because it had been such a gendered issue for a long time at the bar, when the clerk said to me, so would you like to do, family, no pressure, And I said, well, I do have 2 master's subjects in it. Oh, okay. So they immediately booked me to go and do a care and protection case at the Children's Court, which I knew absolutely nothing about.
Was that the ones, I remember you once told me about a case which you ran where the parents both had an intellectual disability, and you were quite shocked. Well, the question that we were talking about is, do parents with an intellectual disability get treated differently to parents who don't have an intellectual disability, and are the expectations of how you will look after children higher because you have that intellectual disability?
Yeah, I remember that case. The parents had 8 children and they lost all of them in the end. But, my client was the mother who was lower functioning intellectually, and I remember her saying to us, we should have stopped at 4. I always said we should stop at 4. It was when we got to 5, it was too many for us to cope with. But her husband had been one of a family of 8, and he always wanted to have 8 children. To have that family experience back again, it was, you learn a lot about people doing cases in the children's court.
Are there any good stories?
There's many good stories. Most of the children's court ones are sad, but every so often, there was a lovely little highlight, and I can remember appearing once in a case where the permanent care order was being made for this child to stay permanently in the care of the foster family. And the magistrate knew that this was a time of great import, and he should say something. And he ended up congratulating the child on being intelligent, which of course was the one thing that the child had no control over. He was well behaved, he was diligent, he'd worked hard at school, he'd done all those things, but the one thing that he was just random chance was the fact that he was intelligent.
I know what he means though, like in some ways, because he was, having a child with an intellectual disability, sometimes that's exactly what people have said about her. She's quite intelligent because of that, because they can navigate socially and be able to meet those demands of what it is to fit in.
Well,
diligent,
I think
hardworking.
And I think one of the things that we understand now as a community a lot more is that there's more than one sort of intelligence. We have, particularly, around here, we have an enormous number of highly intelligent, academically intelligent barristers who are around us, but not all of them are emotionally intelligent.
No.
So you get people that are socially awkward, but intellectually brilliant. And there's a place in law for all of them.
Oh, for sure.
And, I'm very grateful for my colleagues that have that extraordinary capacity for black letter law. I
don't think it's a strong suit.
No, it's when you think about personality a bit at the bar, I think about personality a bit in a lot of contexts. And what I know about myself is I have an enormous capacity to absorb information if I have a story to put it into. So for me, the case theory, the story comes first, and then I can test the facts. But it's only a story, it's only an idea. So if the facts don't fit it, it's like, maybe that's the wrong idea. Let's just change the story and let's just see if it fits. Whereas if you practice in criminal law, it's really useful to have the type of brain that remembers a whole range of facts and you can pull them out of your brain and put together a sequence of what happened at any time. And you'll find that a lot of criminal barristers have a great passion for history. One of their hobbies might be studying the trials of Ned Kelly, for example, because they have that extraordinary capacity to remember detail and remember facts. Whereas I start from the other end. There's a great debate at the bar about how a brief should be put together. And everyone will tell you that they know exactly how a brief should be put together, but basically they're telling you, this is how I like to have a brief. So some people like to have the documents in chronological order from the oldest at the top to the newest at the back. For me, I want the last thing that's happened on the top because I want to know where we're at so that I can then look at where we've come from. And it's a different, way that you group things. So you'll never get the same answer from different barristers because it depends on how you work. Even in family law, we do a lot of drafting of consent orders together if we've got an agreement. And having worked with them for such a long time, I now know which colleagues need to sit down and write it out, and then happy to talk about whether to change it. and which ones can do it collectively. And it just depends on your personality type.
Is that why you think you've made such a good mediator? Become such a good mediator because you're much more likely to look at the big picture rather than just the black letter law as such in any situation?
I think it's why I'm particularly drawn to mediation. And, you know, because on one level I love running a case. You know, like you are truly alive if you've had enough sleep and you're ready. But, you know, you truly, if you're prepared and you've been able to get enough sleep and you've got the brief in good time and it's, you know, in bed in a nice order.
Which always happens, of course.
But, you know, when you're on your feet and you're cross-examining and it's going well and your brain is in gear and you're looking for the nuances in the answers and you're picking the holes and, you know, you are extraordinarily alive at that moment. And it's quite addictive. You know, that's clear, that adrenaline rush that comes from doing a case. But it's not all that satisfying for the clients.
No.
You know, great for the practitioners, not all that satisfying for the clients.
Because somebody will definitely lose.
Yeah, and what mediation is, with mediation, you are assisting the client to take their own decisions about the case and to take ownership of resolving the dispute. And that's a powerful gift to be able to give to someone, the benefit of the experience. And you need to work with them either as the mediator or as counsel assisting in a mediation. And you need to build a trust with them, and then you need to help them think out what the possibilities could be. It's so tempting and to give people the answer. And one of the things that I've noticed in the role that I do in the organisation, AFLAM, that I'm on.
What does AFLAM stand?
It's the Australian Institute of Family Law Arbitrators and Mediators, and I'm the Victorian representative on the board of that. But even before I was doing some mediation coaching for them. And so when they run a training course, they've got scenarios that are played out, and they're the standard little ones that, you know, same little mediation. I've never seen the same outcome come in those, you know, the number of times that I've done those mediation coaching little stories, they've never come to the same outcome. But what you do see, particularly when you are coaching, is you see the moment when the trainee mediator forgets to give ownership to the people who have the dispute and starts to steer people towards an answer. And that's you get this wide outcome. So when you do mediation, you have to have a great awareness of yourself, what your tolerances are for letting people have space and letting people explore. We're always telling mediators to sit back in the chair, get out of the dispute, listen, question, ask curious questions, let people have that space to find the solutions for themselves. If you want a solution given to you, go to an arbitrator or go to a judge. But mediation is a space where people can take ownership. And getting your client ready for a mediation is a process of getting them ready to understand enough about what the possible range of outcomes are so that they're ready to work out what they'll let go of and what they need to hold on to.
That's really good advice, and it's exactly the question that I was going to ask you. What makes a good mediator, and what skills do you have to have as a legal practitioner in preparing your client? You've answered it without me having to ask the question.
Well, I've got a little bit more to say on that. And one of the things that I discovered when I did the bar readers course all that long time ago now. And the point that's made really clearly is that, and Julian Burnside was the guest lecturer who really made this point really clear. He said, being a barrister is something you can learn. Cross-examination is something that you can learn. Being a natural at it is probably a disadvantage, because you cut corners and you don't do the preparation, you don't think about the questions. Mediation's the same. Mediation is something that you need to learn. So a lot of people will think, okay, that person's a barrister, they can mediate that dispute. Well, no, what you'll do is you'll settle the dispute as if you were running litigation. And you'll pick a side and you'll end up nudging towards that solution. And that's very much a evaluative type of mediation, where you come to the mediator, you give it a go and you say, well, what do you think? Do you both want me to say what I think? Because what you say is going to be the number. And I learned that way back in those consumer credit negotiations, and one of those big cases that we did a national mediation, and instead of doing cases one by one on these group actions around the country, and our judge mediator said to me, tell me, Emma, what is it that X $1 million says to you that Y $1 million doesn't? And I'm thinking, why did he say a number? And the QC who was assisting New South Wales, because they had better legal aid funding, the QC that was assisting them said, well, there you go, people. This case will settle for Y or it won't settle. And I thought, what did he do? And that's why I started studying mediation. What was it that he did that then said that's the answer? And, you know, and the QC said to us, he won't have said that in this room unless he's also said something, you know, the opposite mirror question in the other room. And, you know, it's... What makes a good mediator depends on what type of mediation you're doing. And I am attempting to practice a facilitative mediation model where you assist people to reach the decisions themselves. It's wonderful working with a team of lawyers as the mediator, where you've got your the clients are each represented by solicitor and counsel. But it's also really satisfying working direct with parents, because I went and did study and a graduate certificate to become a family dispute resolution practitioner, which some family law barristers and solicitors have also done that extra training. And working, as I do occasionally, direct with parents and not acting for either of them, and assisting them and seeing how they might have, you know, got annoyed about that, and then it's reacting here, and assisting them towards cooperative parenting, that's gold.
It is. It's really is. In fact, Emma, you've inspired me. I've been thinking about going overseas and studying next year, and especially in Germany, and there is a good mediation course there, and I was tossing up whether I should spend the money to do it or not, but no, you've really made it such an attractive option.
I think that, I mean, we've seen mediation really take on a role in family law. It used to be an alternative to court. Now it's required as part of the court processes. And if people don't go to private mediation, they've employed a range of registrars in the Federal Circuit Family Court who are trained in mediation. So they've got the options of external or internal. And it's partly the court can't possibly resolve every family law dispute. Can't possibly. It needs to decide some of them, but with assistance, the theory is that people can take control and do that themselves. So I really see not just that do mediation because you'll never get on in court, do mediation because this is a better way to manage a dispute. And our skills as lawyers are well used in assisting people to resolve the disputes themselves, rather than, keeping them having to come back to lawyers all the time when something goes wrong.
Well, especially, like you said, in credit and consumer law, because they don't have any resources. You know that if they can't resolve it themselves, they're likely to get a much worse outcome. And I do think that that's a skill that we develop over time, and I think people feel better about themselves if they've achieved it themselves, and are more likely to commit to it going forward. So I couldn't agree more.
Yeah.
I just thought I'd ask you two more questions, but they're big questions because I'm conscious of the time. This is unusual for me, but I'm conscious of the time, and I just really wanted to ask you something about family law, because one of the things that has struck me, not practicing in this area at all, but I noticed how much relationships have changed since I was married and starting to when I was young. Do you think that the Family Law Act has kept up with the changing nature of relationships, particularly in the way that we now? I was just thinking more about debt and money, because when we grew up, it was often the case you found somebody, you got married, you opened a joint bank account, and you built your assets together over time. Now it's you might get together, you might even marry, and you might always have separate finances and we treat each other much more as individuals, even within a relationship. But the Family Law Act still sees people as couples, ultimately, when there's a separation.
It comes as a great shock to people who have always managed separate finances, that the family law imports onto the relationship an obligation to support the other person. And I mean, this is probably one of the, and we can't just say, there should be more information about, what you're doing when you get married, because the obligation to maintain a spouse, the state puts an obligation onto the family as the first port of call for support, and that's not just family law; it's social security law. It's a range of different things. In other countries, there's actually a statutory obligation to support your parents, not just support your children. So that concept is probably the hardest one for people to get their head around, the fact that you might get a divorce, but you might still have a financial responsibility going on. Then what we've got in recognising other types of relationships is that the obligation of spousal maintenance is on those relationships as well. There's a lot of confusion for people about whether they're de facto or not. And de facto definition is different across different Commonwealth and state situations. And are you de facto for Centrelink, and are you de facto for the fact that there's a 2-year ordinary limit. You need to have had a relationship of 2 years, unless you've got one of the exceptions, you've got children or you've had massive significant financial contributions, etc., before you can apply for a property settlement in family law. Some people think they're not de facto until they've been living together for 2 years. And that's how a lot of Centrelink mistakes happen. And so there isn't a great understanding of that among the community. But what they also don't understand is that once they meet that definition of de facto, the spousal maintenance obligations put onto them by the community that says, well, you were together in a close personal relationship, domestic relationship, so therefore you're the first line of support now. So there's a confusion about that. And that's about people's understanding of what the Family Law Act does, which is not great.
But it's also, but can I just say this, Emma? It's also quite old-fashioned in a sense, and possibly that needs to be a relationship of support between spouses, particularly once you separate. Or
is that
or
old-fashioned, or is that... I actually see it as government policy.
Yeah, it is.
The government policy is that the family is the first, so someone who's on a single parent pension, a benefit, when they get together in a new relationship, hey, presto, they lose the support of the community and they're expected to be supported by their spouse. So we put that, and on one level, it's really important to recognise the family as the fundamental unit of society, but what different governments have done with that, and the obligation to apply for child support before you can get government benefits, the obligation to apply for spousal maintenance before you can get government benefits. That's a community decision, and we don't have a universal wage model of society where we say everyone's entitled to a certain level of support that doesn't depend on some other individual doing it. So, in answer to your question, is the Family Law Act completely out of whack with society? No, I think it's actually just a reflection of society. The Family Law Act understands that families come in all shapes and sizes and configurations, and it's not gendered. And it is able to deal with, all those different situations. The problem for members of the public is that anything that requires judicial interpretation or discretion, that's a really expensive decision to get to, because you have to go through the processes, and someone can have an opinion, no, it wasn't de facto, and someone can have an opinion, yes, it was, and you have to run a full trial to get to that point of deciding that. And family law costs have really gone beyond the reach of ordinary people. If you're not working and you're eligible for legal aid, you'll get some decent representation without having to pay for it. If you've got lots of money, you can play forever. But it's this enormous number of people in the middle where they're making extraordinarily large financial decisions. It's not uncommon now to get to a trial and people have spent $200,000 on both sides. The family home has gone because these are important. Decisions about children are so dear to people's hearts and so important for them that they stake their life savings on it and their parents' life savings on it. So they're big decisions.
Big decisions, Emma. The big decision we've got to decide is that we've got to finish soon. So I'm just going to ask one quick more question, because this is the question that I always like to ask. Building relationships is critical to your work as a barrister because you're relying on briefs from solicitors most of the time. What relationships do you want to build and retain in your role as a barrister? How do you do it, and how's it different to when you were a solicitor?
That's a great question. It's got a couple of different levels. Of course, the important thing is, where is your next brief coming from? And so it's about having a reputation and being able to work as a team. I like to work as a team. I'm self-employed, a solo person, but I really like working as a team. So who is in my team? My instructing solicitors are in my team, and I like working in that way. But also, this crazy profession that has worked for years in the way that it has at the bar, where all of us are individuals. We are all actually competing with each other for work, and yet the way in which the bar is so collegiate and so supportive, and people go out of their way to support each other, it's phenomenal. I'll tell you one little story, and it was I'd been at the bar for 6 months, and I'd taken on a case in discrimination case. I was trying, at the time when I was trying all sorts of different things, and it was intense and it was exhausting, And I'd got to a point in the day where I knew that what had happened was significant. I didn't know what to do. And I thought, oh, God, I need to make a phone call. So I actually, asked the tribunal member to leave the bench, and I went and rang my mentor, who was a volunteer. I read with the wonderful Jocelyn Scutt. And so I ring Jocelyn and say, Jocelyn, what do I do? And she said, okay, well, your opponent is a reasonable person. He's not going to want to call 2 more witnesses to show that your client hasn't just made up what she said in the witness box. Show him the documents that you've got. He will make the concession and it should all work. For the rest of the day, I had this sense of, oh my gosh, I'm taking these people's money and I don't know what I'm doing. I didn't know what to do. I had to go and ask. I didn't know what to do. And I was in the practice of going and sitting down having a coffee. I was young then. I could have a coffee at the end of the day of court. And with my instructing solicitor, and we talk about what to do the next day. And she said to me, coffee? And I said, coffee? Coffee? I need scotch. And we went back up to Chambers, and Equity Chambers, which is now gone, had a mixture of small firms and barristers all renting from Equity Chambers, and there was one senior barrister on the floor who hosted Friday night drinks, and he sort of said to her, how'd you go today? Like the juniors off at court. And she said, oh, I think I've tested it today. I offered her coffee and she wanted scotch. And he said, oh, I think we've got some. And he went looking for the bottle of scotch. Someone went down to the fridge to get the ice. Someone else heard the chink of glasses on a Wednesday night. And all these people who owed me nothing, they weren't my boss, they weren't, they sort of said, and it was like, sit down, tell Uncle Tony all about it. And I got to that point and I said, and I didn't know what to do. And he said, stop right there. You knew you identified the issue, you knew where there was a problem, and you found out what to do. So you did know what to do. And he sent me back into the next 2 weeks of that case with the confidence that I had the skills in order to do the case. The relationship about where's your next brief coming from a solicitor, really important. Your relationship with your clerk, who is your booking agent as well as your moral support, and assists with your practice and developing your practice. Those are important. But for me, there's something very, very special about the bar, and I think the Victorian bar, very, very special. And it's that people that have no reason to be nice to you at all are supportive and interested in your career and your day at court, and that's a wonderful thing as a lawyer.
And a barrister, Emma. And I think we'll leave it there, Emma. That was so delightful. Thank you so much for doing this with me. I really enjoyed it.
Well, Loretta, it's just been wonderful to see you at the end of our 2 years in person.
Yes, because we've been trying for 2 years.
We've been trying for a while, but, it's wonderful. Thank you.
No, thank you. And thank you, Emma, and thank you to my team who helps me put this together, Oliver Galkey and Francis Lockhart. Please, if you want to find out more about Emma, I have show notes with each episode that's available on my website, www.lorettacrete.com. Please remember that if you have any suggestions for other interviewees, just drop me a line. Thank you, and see you next time on another episode of Lunching with Lawyers.